I am pleased to be joined in the room, if not at the table, with Cheryl Sensenbrenner. My co-sponsor of this legislation is Jim Sensenbrenner, the ranking member of the Judiciary Committee. Mr. Sensenbrenner and I have worked long together on issues regarding disabilities, and I thank his wife, Mrs. Sensenbrenner, who has been a leader in her own right on this issue, who is, as I say, with us today. One other person I would like to mention, the real hero of the Americans with Disabilities Act were those with disabilities all over this country who came to Congress and told us of the discrimination to which they were subjected. A galvanizing leader in that effort was Justin Dart. Many of you know Justin Dart. His widow, Yoshiko, is in the room with us, and she has, as she does so often, have Justin's hat with her. His admonition to us was to keep the faith and keep the focus on making sure that the opportunities promised by the Americans with Disabilities Act became the reality. Yoshiko, thank you for the efforts that you have made. I want to thank you for holding this hearing on the ADA Restoration Act that was introduced last July 26, and which already has 244 co-sponsors, a broadly bipartisan co-sponsorship list. Let me assure you of one thing at the outset of my testimony. The purpose of this legislation, we believe, is straightforward and unambiguous. The bill does not seek to expand the rights guaranteed under the landmark Americans with Disabilities Act. Instead, it seeks to clarify the law, restoring the scope of protection available under the ADA. It responds to court decisions that have sharply restricted the class of people who can invoke protection under the law. And it reinstates the original congressional intent when we passed the ADA, and which I might say was a collaborative effort between President Bush in the late 80s and 1990 and the Congress in a very bipartisan way. When the first President Bush signed the ADA on July 26, 1990, he hailed it as, and I quote, the world's first comprehensive declaration of equality for people with disabilities. He was absolutely correct, and it has been viewed as such around the world. This landmark civil rights law prohibited discrimination against Americans with disabilities in the workplace, public accommodations, and other settings. We knew that it would not topple centuries of prejudice overnight, but we believed that it could change attitudes and unleash the talent of millions of Americans with disabilities. And we were right, as Mr. McKeon has indicated, and Mr. Andrews also. Since its enactment, thousands of Americans with disabilities have entered the workplace, realizing self-sufficiency for the first time in their lives. However, despite our progress, the courts, including the United States Supreme Court, have narrowly interpreted the ADA, limiting its scope and undermining, I suggest to you, congressional intent. When we wrote the ADA, we intentionally used a definition of disability that was broad, borrowing from an existing definition of the Rehabilitation Act of 1973, our assumption being that that law, in effect for 17 years prior to the signing of this bill, had been interpreted many times, and therefore we were trying to eliminate controversy rather than create it. We did this because the courts had generously interpreted this definition in the Rehabilitation Act, and we thought using established language would help us avoid a potential divisive political debate over the definition of disabled. Therefore, we could not have fathomed or anticipated that people with diabetes, epilepsy, heart conditions, cancer, and mental illness would have their ADA claims rejected and kicked out of court because, with medication, they would be considered too functional to meet the definition of disabled. In other words, our premise now is that if I discriminate against you because you have epilepsy, but that in fact you can perform a major life function because the medication that you are taking mitigates the effects of your epilepsy and prevents seizures, that the fact that I've discriminated against you and said you can't have the job because you have epilepsy will not be covered under this act. no one on this panel, from right to left, Republican or Democrat, could have conceived that such a conclusion would have been reached. The Supreme Court decision in Sutton, Kurtenberg, and Murphy cases in 1999 and the Toyota manufacturing case in 2002 are, simply put, misinterpretations of the law. I wrote an op-ed piece in the Washington Post shortly after one of those decisions stating that. In Toyota manufacturing, for example, Justice O'Connor, writing for the court, said the terms, quote, substantially limited, close quote, and, quote, major life activities, close quote, need to be, and in her words, strictly interpreted to create a demanding standard for qualifying as disabled, close quote. That is a conclusion that I think none of us would have reached who voted for the act, nor would President Bush when he signed the act. The court went on to say, and again I quote, substantially limited means to prevent or severely restrict. This was not our intent when Congress passed the ADA. Again, if I discriminate against you because you have epilepsy, the fact that your epilepsy does not adversely affect your ability to do the job for which you're applying seems to be irrelevant. It is the discrimination that is relevant. We did not anticipate that, contrary to our explicit instructions in the legislation, the court would eliminate from the Act's coverage individuals who have mitigated the effects of their impairment with medication or assistive devices, as in Sutton, Murphy, and Kurtenberg. Again, this is not, I suggest to you, what the Congress intended. We intended a broad application of the law. Simply put, the point of the ADA is not the disability. It is the discrimination. It is the prevention of wrongful and unlawful discrimination. Let me be clear. Only people who can prove that they have been discriminated against on the basis of real or perceived disability have potentially valid claims under the ADA. Such people must also prove that they are qualified to do the job with or without a reasonable accommodation. Mr. Bartlett and I and members of Congress and outside advocacy groups, business and consumers, prospective employees, all spent a lot of time on this so the Act would be a reasonable Act. H.R. 3195, introduced by myself and Congressman Sensenbrenner, and now 242 others, the former chairman of the Judiciary Committee, Mr. Sensenbrenner, we designed it to restore the broad reach of ADA that we believed was plain in 1990. I think President Bush's statement upon signing reflects that belief. Among other things, the bill will amend the definition of disability so that people who Congress originally intended to protect from discrimination are, in fact, covered under the ADA. Secondly, prevent courts from considering mitigating measures. The issue was not whether measures could mitigate your disability. It was the discrimination based upon your disability, such as eyeglasses or medication, when determining whether a person qualifies for protection under the law. Thirdly, modify findings in the ADA that have been used by the courts to support a narrow reading of disability. Almost every civil rights statute, indeed every civil rights statute we have passed, were intended to be and were instructed to be broadly interpreted to affect the objective of eliminating arbitrary and capricious discrimination. Specifically, this bill strikes the finding pertaining to 43 million Americans and the finding pertaining to discrete and insular minority. Let me conclude, Mr. Chairman and Mr. McKeon, by noting that this past July 26th, we marked the 17th anniversary of this landmark law. I believe that its promise remains unfulfilled, but very much still within our reach. Passage of this legislation is imperative to restoring congressional intent, to achieving the ADA's promise, and to creating a society in which Americans with disabilities can realize their potential and have a confidence that they will not be discriminated against, notwithstanding their ability. Thank you, Mr. Chairman.